Welcome to Legalese. Legalese is a presentation of the Northern Middlesex Bar Association. It's designed to bring issues of interest to the community in the hopes that they may be informative to those of you who are watching. I am joined today by attorney Richard Larkin from AIR. Richard was kind enough to appear on a previous program that we had earlier this year. The name of that program was Good and Clear Record and Marketable Title. This program is somewhat a follow-up of that show, and the title of this show is Dealing with Title Defects. Richard, welcome.
Hi, Chris. Glad to be here.
Thank you. Richard, we talked last time about what makes good and clear record and marketable title, how one searches and determines whether you have such a thing. However, there are situations where, in fact, you do not have good and clear record or marketable title, and that's referred to as a title defect, correct?
Mm-hmm. That's correct.
And what does one do when presented with a title defect with respect to land that is to be the subject of a purchase?
Well, Chris, one method that often works is a self-help method. Anytime there's a defect in title, it usually means that there is either someone or some group of people out there or that may have a claim against the title in question, or that may appear to have a claim. And if that's the case, sometimes one can identify those persons, locate them, receive releases from them, and if their rights are released or their interests are released, then the title is clear.
What do you mean they may have a claim to the...
Well, there might be an actual claim. There might be some item of record that indicates they or someone who went before them, whose shoes they stand in, had a claim against the property.
Okay, can you give an example?
Or that could be the case.
Could you give an example on what you may have seen such as
yeah,
such a
I
thing?
can remember a case. There are a bunch of ponds in AIR that you may be aware of, and sometime in the late 19th century, something was done to the dams of those ponds that caused the water levels to drop.
Ponds.
Ponds.
Yes.
Small lakes.
Yes.
And the result of it was, in some neighborhoods, land that had been underwater was suddenly high and dry. And the obvious question that arises, who owns it? In regard to one of those particular parcels, this was in AIR, there was an individual named Fisk Warren, who in the mid-1920s was developing land in and around AIR and took an interest in this particular parcel. Fisk Warren was a well-known, wealthy individual from Boston, a well-known land developer, something of an eccentric. In his day, he and his wife were the leading social lions of Boston. And besides that, he had some unusual notions about property development. In most cases, he was very careful. For some reason, in this case, he determined that the particular piece of property he was interested in would have belonged to one Daniel Fletcher, formerly of AIR. Go ahead.
So he took one of the self-help methods that you're referring to.
Well, he did. I'm going to tell you what that was.
Okay.
He identified this Daniel Fletcher, who died in 1881, as the man who would have owned this suddenly appearing property. He then apparently went around and determined who were Daniel Fletcher's descendants, and he simply went around in the mid-1920s getting them to sign a form of a deed. It wasn't the normal form that you'd be familiar with, where so-and-so grants to so-and-so. They didn't have any names at the top. It simply said, "We the undersigned," released to Fisk Warren, and then he got as many of them to sign as he could find.
And you found this document on the record?
I did, 1925. It purported to be the source deed for this property, but there's a statute that's only been around since the early 70s, but it prescribes a standard by which title examiners will look at titles. It pertains to a situation involving residential property and one where the property owner is paying fees, typically to a bank. But it establishes a standard for searching title, which is now in place and which was probably very similar to what title examiners have always done. And that is what the statute calls for, is you go back at least 50 years, and then you have to come to a deed which on its face looks okay. Well, I would say this deed from 1925 that Fisk Warren was able to get looked odd. It didn't indicate where these people signing the deed had obtained any rights, if they did have any. I remember at the time when I got involved in it, I calculated that he managed to find 56% of the then surviving interests of Daniel Fletcher on that deed. Unfortunately, he missed something important, and that was this. After the death of Daniel Fletcher, all of his heirs got together and they executed a deed in favor of two of their number, which was recorded. He could have found it. A few years after that, of the two who took the rights of Daniel Fletcher, one of them gave a deed to the other. That man's name was Calvin Fletcher, and this happened, I think, in 1902.
So that land stood solely in the name of Calvin
Well, yes.
Fletcher at one time.
Mr. Warren should have been looking for Calvin Fletcher. Now, it's possible he looked and didn't find him, so he did the next best thing. But in any case, one could say that Calvin Fletcher stood of record as a party interested in that property. So when it came my way about 1990, I first undertook to see what I could find out about Calvin Fletcher. I found out two things. One, he had something to do with the Waltham Watch Company. Second, he had loaned some money to an individual, and he took back a mortgage for that loan.
Okay.
In 1912, he signed a discharge of that mortgage, which got recorded. The discharge said on it that he signed it at College Station, Texas. Well, at the time, something popped into my head, and it was an earlier time for me. I was driving around on a Saturday in the fall one time, just listening to the radio, and I suddenly heard, "This is Gil Santos and Gino Capoletti coming to you from College Station, Texas, where the BC Eagles will do football battle with a..." I don't remember who it was, but I checked it out, and it turned out to be Texas A&M University.
Okay.
So I then developed this theory. Calvin Fletcher must have been some kind of an engineer with the watch company, and he went down to Texas A&M, got on the faculty, and so I called down there. Well, they had a file for the man. Turns out, for many years, he was a professor of entomology.
Okay.
That's insects, but
Thank you.
close enough. So,
All right.
not only that, but the man had the wisdom and decency to marry a much younger woman.
Yes.
And that lady had died within the year of my calling the archives at Texas A&M University. Her will was then in probate. And those people helped me in reaching the executor of that estate, and he helped me reach other parties in interest in the estate. We got deeds of release from all of those people, and suddenly that title was clear.
So the title through Calvin Fletcher went to his wife. His wife passed, and you had a fresh estate where you could gather up the executor and everybody else that would have an interest in her estate
And that was
to
it.
sign off.
Yep.
And that was a self-help
That was a
method.
self-help remedy where you get releases from people who can give them.
And you're able to then record those releases, and you now have clear record and marketable title.
Correct.
Okay.
Yep.
What's another method of self-help that might be available?
Well, sometimes a title is good in fact if you know all the facts, but it either doesn't show of record or it can't be demonstrated of record. And in those instances, it is sometimes possible to bring facts to the record which clarify certain facts, which then make the title clear.
What do you mean bring facts to the record?
Well, this case comes to mind, a somewhat interesting case. There was a man named Aaron Birkinshaw. He came to Pepperell from Sheffield in England sometime after 1850.
Okay.
He brought with him from Sheffield in England a knowledge of the knife manufacturing business, and he set up a manufactory in that neighborhood. It was around Heald Street and Sheffield Street, if you know Pepperell. You can still go and see the the remains of his location today. And from sometime after 1850, when he came over here, he first landed in Connecticut and then sometime later got to Pepperell, I'm not sure quite when. Between then and 1875, when the county maps were prepared, Pepperell showed an inset map called Birkinshaw Village, and it showed his manufactory and several other properties owned by him. So in that relatively short time, he made a name for himself and for his business. And he was a man of parts. You could say a can-do person, which in some cases is a good thing. But it's not a good thing if you decide to draft your own will and you don't know how to do it, which is what he did.
What happened?
Well, he had a very complicated will, and in it, among other things, he provided that his real estate was going to go to his son Fred and his daughter Harriet for their lives, but, to quote the will, no longer.
Meaning what?
Well, meaning that when the second of them to die died, their titles were over.
Okay.
The problem was he didn't make provision for what would happen to the real estate then.
Okay.
See?
So
Now,
what happens at that point?
well, I mean, you could say a lot about that. Probably it would go back into the will to be turned around as though Fred and Harriet didn't exist,
Okay.
and probably would have come out to the family. And as a practical matter, on the record, the family did several things that implied that Fred had survived Harriet. It made a difference who survived whom. And then it went on from there. The problem was, going back to that 50-year rule that I told you, it was not possible to do a good, prudent title without going back to Aaron Birkinshaw's will.
Okay.
And when you got there, it was a mess. And just to give you one tiny little insight, a little collateral from my story, but there was a period of 10 years from his death to a certain point when the family realized they had missed something, and they needed to go to around to all different parties to get signatures to clear it. Okay? In that 10-year period, to get the signatures necessary to take care of that, there were 54 signatures on the deed.
Wow.
Then, as a collateral part of what I did, but I won't get into it here, in the 1980s, when I looked over at what they had done, I realized that when they got those 54 signatures on the deed, they missed 2 people.
Huh.
I was able to find them in Lowell, and in about 1983, you know how many people it took to cure that? 4. So you never know how these things are going to go.
That's nice.
Now, that's a side issue. Getting back to Fred and Harriet.
So it was important that Fred, from your perspective, that Fred was to survive Harriet.
Yes, it's a complicated thing, and I won't get into the details, except
Okay.
to say Fred's surviving Harriet was critically important to making whatever they did after that stand up.
But you didn't have the information about who had survived who.
There was nothing on the record about Harriet and
Okay.
her death or anything else.
All right.
So I went off the record and I started looking around, and I stumbled upon a volume called Biographical Sketches of Important Men of Middlesex County.
Okay.
And in there was a biographical sketch about Aaron Birkinshaw's son, Fred. And in it, it was mostly about how he had taken over the father's business and he ran the knife, factory for so many years and this and that.
This is the Fred in question.
The Fred in question, yes. And, things of that nature.
Okay.
There was one sentence about his other comments about his family, and there was one sentence about his sister Harriet.
Okay.
It said, his sister Harriet married Walter Weller and died in the Indian Territory.
Okay.
That
What do you do with that?
Well, that wasn't very encouraging because we needed to know whether she died before or after Fred, and that told us nothing. So I was in a bit of a quandary until I managed to buttonhole a police officer whom I had known for many years in Pepperell, And I asked him, what do you know about the Birkinshaw family? And he said, well, not very much, but there is an elderly lady in town named Birkinshaw, and I know her, and I'd be willing to, introduce you. So through him, I was able to make an appointment with Audrey Birkinshaw, who turned out to be Fred's daughter.
Okay.
And I made an appointment to see her, and I went up to see her at her home. And I went in there, and there was the dining room table mounded high with all sorts of legal documents, just piled all willy-nilly. And so I sat down to all these legal documents, and I'm looking through them, and it didn't take long for me to figure that nothing in this pile was going to help me. It was mostly about people who had died in the family and probates of estates and things, but nothing about Harriet. So I didn't want to seem too abrupt or ungrateful. She had gone to some trouble to help me, and I didn't just want to, run out of there, but I was trying to think of a graceful way to make an exit. And while I was doing that, she was sitting in an adjoining room with a great big wide door by a brightly lit window, and she was sort of chatting all through the process. And suddenly I heard, off to the side, oh, listen to this. Sister Hattie died today. I said, what? I said, Miss Birkinshaw. Well, what was that again? She said, Sister Hattie died today, September 7th, 1887.
She was reading from something.
Yes. Turns out she had her father's diary. It was one of these little pocket diaries. It had dated pages, but he was crossing out the date and putting in his own date.
Uh-huh.
And he wrote in the date of his sister's death, her aunt, whom she had never known. I mean, she was born long after 1887, but those were the facts, and those kinds of family records are given a great weight in legal situations. So we prepared an affidavit to be signed by Miss Birkinshaw, saying that this is the story, and here's the family, and she was in possession of her family's records. And we had this entry in her father's diary. We recorded that, and all those titles coming down from then were suddenly straightened out.
So you had discovered the facts you were looking for.
Yep.
You put them in an affidavit. You record the affidavit.
Correct, and that cleared that title.
What entitles you to record an affidavit in that regard?
There's a statute, Chapter 183, Section 5B, which specifically states that any person who has facts that would tend to clarify a title may, put them in the form of an affidavit, sign it on their oath. The statute requires that an attorney at law needs to sign that, verifying that it would be of material, assistance in clarifying a title. I think, Chris, if I remember correctly, you may have signed one or two of those yourself through the years, yes. So we prepared that kind of an affidavit for her, and it just introduced that fact that needed to be known, and once it was known, everything else lined up.
And that cleared that title.
Yep.
So we've talked about self-help. When self-help fails, what are your remedies? What are your options?
Well, your options are some kind of legal action. Most often it's in the land court.
Okay.
And this brings to mind another situation.
Okay.
In that case, there was a parcel of land in a town. I'm not going to say too much about it because it's a little too close to, living people and all that. But suffice it to say that it was owned in 1904 by a couple when the Mrs. Kingsbury, had a fall about the age of 50. She died of the fall. And she owned that parcel together with her husband. Now it's clear, the way they acted afterward, that the husband thought that upon his wife's death, he was automatically the owner by the deed. In fact, that wasn't the case. There are some deeds drafted in that way that cause, the surviving owner to be automatically the owner upon the death of the other. This deed was not of that kind, but he thought it was and treated things afterwards accordingly. In truth, that property should have gone into a probate, and in that instance, Mrs. Kingsbury's estate was probated. However, she didn't have a will, so in that case, the statutes write a will for you. It's called the Intestacy Laws, and it sets up a protocol of who inherits what. And in those days, 1904, the surviving husband would have inherited everything if the total value of the probate estate had been $5,000 or under.
Okay.
Interestingly enough, as I say, there was a probate of her estate, and the inventory stated that the total value of the estate was $5,250.
Just over the 5,000.
Just over the line. Well, however, that inventory value, that's something simply filled out by, the individuals in the family, so to speak.
Okay.
That itself does not determine the $5,000 issue in terms of who gets the estate, because if it doesn't pass to the spouse, being under 5,000, then you go to her so-called heirs at law. That would be her nearest kin. Mrs. Kingsbury didn't have any children, and so her heir at law would have been her mother. And her mother was mentioned in the proceedings as a Rebecca Mead. So, I wasn't able to find anything out about Rebecca Mead, but this is interesting. The court, this would have been the probate court in Cambridge, they were actually going to let me pursue an action to go back into that 1904 estate and obtain a valuation of the estate as of 1990, say, as we say, nunc pro tunc. We're doing it now, it counts for then.
Wow.
And it would have solved the problem. There was reason to believe that the $5,000 figure, once that process took place, was going to come down from $5,000. In doing it, one would have had to have notified the heirs and survivors of her mother, Rebecca, we thought, because it would have been Rebecca or anybody coming after her who would have been able to step in and say, no, wait a minute, I think it's 5,000, because if it's above 5,000, they become interested.
Sure.
So we had to find what we could about her mother's descendants. Well, as I say, I didn't find anything about that, but I did.
So you tried self-help at that point.
Well, before that, I was able to find that her father had predeceased her by about 2 years. He had a will. In the will, he urged his children, that would have been Mrs. Kingsbury and her brother, quote, to be sure to look after my wife, Louisa. Okay? So that seemed a little odd, and at the time I took it, and also he was living in Littleton when he died, and we knew from Mrs. Kingsbury's estate, we realized that Rebecca was supposedly living in Ayr. So I took it at the time that he had a second wife, Louisa. She probably wasn't very popular with her stepchildren, and in his will, he seemed to be telling them, you may not like her, but please do your duty.
You were drawing conclusions based on
I was
the
drawing
language.
conclusions best I could. So I did know a little bit about Louisa coming down, but she didn't appear to have any interest in the matter.
Okay.
I spent at least 2 years trying to track this down. I remember having my secretary, Barbara, send communications to probably 30 towns within a radius of where we were. Do you have any Rebecca Mead records? Nothing. So then I went to the State Archives at Morrissey Boulevard. I had some reason to believe that Mrs. Kingsbury's mother might have come from Harvard. And sure enough, after a certain amount of scrabbling, I came up with a birth certificate, Rebecca Louisa Mead, 1836. Town of Harvard. So all of a sudden it became apparent that never mind what I thought, Rebecca and Louisa were one and the same person.
You had guessed wrongly.
I had guessed wrongly, yes. I was rash, jumped to a conclusion. So now it became important to track down, and by the way, there were only 2 places where Rebecca showed up, in her daughter's probate and on that birth certificate. Every place else it was Louisa.
Wow.
Okay, yeah. So then it became a question of tracking down, very much like the other 2 cases I mentioned, tracking down people who came down from this Louisa. And my first purpose, if it could be done, was I was going to see if I could get them to sign releases. It turned into a vast number of people, many, many of whom I spoke with on the phone. And the truth is, a great many of them were willing to sign releases.
Some were not.
The problem was, some of them changed their mind, and in particular, a couple of them were under what we'd call a legal disability, where they weren't competent and they were not in a position to sign anything, and so you wouldn't have been able to cure it that way.
So at that point, self-help not working,
Yeah.
what's available?
Yeah, so then the remedy in the probate court, doing the evaluation, retroactively, that would have been a court remedy. But most title curing remedies are in the land court, and the one that comes to mind most frequently is called an action to quiet title.
Okay.
In that case, you believe that there's a person or a class of people, a group of people, whatever, who may have a claim, either do have a claim, at least historically, or may have a claim to the property. And essentially, in that action, you call upon them to step forward, you call upon anybody, plus the people whom you've identified, to step forward and defend their title. And the important thing about it is, at the end of it, the decree of the court is said to go to the property.
Okay.
Using a Latin phrase, it's in rem, meaning it goes to the property, it doesn't go to the people, and so that clears off claims against the property.
All right.
And it's fairly comprehensive.
Now, there are other claims that can be brought through land court. Unfortunately, we're running at the end of our presentation. But Richard, I thank you very much for coming and speaking with us on this topic and sharing with us your wisdom and your war stories, so to speak.
Yes.
And I thank you all for watching. This has been a presentation of the Northern Middlesex Bar Association. This is Legalese. I would caution you, if you do have issues dealing with land or otherwise, take them to local counsel. Don't rely on anything that's being said here to answer your questions. Talk to an attorney. Thank you.